Planning for long-term care involves an analysis of legal issues, financial issues, and social issues. If a loved one is looking at long-term care in their future, there are 5 significant mistakes to avoid. I'll go through them now. Number 1, have a power of attorney. You want a power of attorney for yourself, and you want your loved one to have a power of attorney. Every single person has money, accounts, investments, property, real estate. If you lose the ability because you're unconscious, you had an accident, you have an illness, to deal with that property and to ideally preserve and protect that property for your family, you need to legally authorize another person to take steps to do things with that property, even pay bills. That's why you have a power of attorney. When families come to us in crisis and dad needs to go from the hospital to a skilled nursing facility for longer term care, the first thing we look at is the power of attorney. Because if dad's in no shape to move money around to protect it, we look to the kids or the spouse to see if they have the power under a power of attorney document. Mistake number 2, if you have been given the power of attorney from a loved one, don't sign documents such as an admission agreement to a nursing home or some other legally binding document with your name. You write your name and then comma, POA for your loved one's name. That way you avoid being on the hook personally for financial obligations that your loved one might incur because of the long-term care. Mistake number 3, when your loved one is leaving the hospital and being told they have to go to a skilled nursing facility to rehab from an injury or an illness, whether it be a fall and an orthopedic injury and therefore physical therapy, or whether it be a stroke and needing occupational therapy or speech therapy, there's a couple of mistakes to avoid. Number 1 is make sure that your loved one was admitted to the hospital for at least 3 days. In Pennsylvania, the law requires that hospital to give you a piece of paper that indicates whether your loved one was kept overnight on observation status or actually admitted. If your loved one was admitted to the hospital, then Medicare will pay for the skilled nursing care that follows. And that's a hefty price tag for Medicare to pick up instead of your family paying for it. The other thing to keep in mind when leaving the hospital and looking for a skilled nursing facility is find one that participates in Medicaid. There are some out there that are not set up to take Medicaid. So when Medicare stops paying for that short-term physical rehab, the physical therapy, occupational therapy, and so forth, you either have to privately pay at a very high rate, maybe $10,000 a month for that care, or you have to bring your loved one home before it might be safe to do so. If the skilled nursing facility accepts Medicaid, then it's possible to get your loved one qualified for Medicaid to then start paying for the long-term care, especially if there are multiple things going on, not just a fall, but also dementia, not just a fall or a stroke, but also some other illness that's going to require long-term skilled care from licensed professionals. So just to make things easier, find a place that also takes Medicaid for longer term payment. Number 4, the biggest mistake possibly of all of them is gifting when you want Medicaid to pay the cost of $10,000 or $11,000 a month for long-term care. So when you apply for Medicaid, which is the way that most of the middle class in this country pays for long-term care, they're going to look back 5 years at line by line at your bank statements and your tax returns. What are they looking for? They're looking to see if you just gave away your money in order to become poor and then apply for Medicaid. So they're going to look at any month where your gifting was over $500. And you might think, well, we don't give gifts, but it's much more complicated than you think. Have you given a car to somebody either for free or for not anywhere near what the car is worth? Have you paid the housing expenses of someone in the family for them and it's not your house? Have you given holiday gifts? Have you given wedding gifts, birthday gifts? Any one of these, anytime you're transferring money of yours and not getting something of fair market value in return, is a gift. And depending on how much it is, it could turn into a penalty where Medicaid won't kick in until you've paid for a certain period of time at the high private pay rate. Even if you've done some gifting, there are ways to resolve that issue and get you qualified for Medicaid, but you need to consult an attorney. Finally, the biggest mistake after all of these is avoid having your children get sued for the cost of your skilled nursing care. Did you know that in Pennsylvania, we have something called the filial responsibility law, where nursing homes can sue your children for the cost of the parent who has run out of money? There's a lot of ways you can run out of money when it costs $10,000 or $11,000 a month to be in a nursing home. And when you've run out of money, maybe because you were engaged in gifting and Medicaid won't kick in, or because of some other lack of proper planning, you're out of money and now they're going after the children. That's a very avoidable problem because elder law attorneys, such as those of us at Keystone Elder Law, can guide you through this and plan ahead so that your children are not stuck having to pay for your nursing home costs. If you want to ask us more questions about this, we're happy to talk about it. We love to talk about these issues and help families plan ahead. We are at KeystoneElderLaw.com. Thank you for watching. Please share this if you think this information would be helpful to somebody else.